Welcome to Guardians of Innovation, Patent and Trademark Law.
Hello, everyone. Welcome back to Guardians of Innovation with Vincent LoTempio. Hi, Vincent.
Hi, good morning. How are you doing today?
Doing great, doing great. Vincent is a registered patent attorney with over 25 years of experience helping inventors, entrepreneurs, and businesses protect and profit from their ideas. I'm Sean O'Connor, and today we're talking about what happens when someone copies your invention and what you can actually do about it. It's all about patent infringement and what to do if someone copies your idea. Vincent, let's start with the basics. What legally qualifies as patent infringement, and how do they determine that?
This is a great question. And most people, most of the negative people too, and you hear this all the time is, why should I get a patent? All they have to do is change it a little bit and I'm not covered anymore. Well, that's really not true. The way a patent works is it's set up, there's all different parts to a patent. There's a background, a summary, a detailed description, a short description of the drawings. There's drawings. There's an abstract that kind of tells you what the basic idea is. But the biggest, most important part of the patent application are the claims. And the claims are what you claim your invention is. And the claims work where they talk about structure and function of what it's made of and how it's put together and what it does. And I always use simple examples of objects or products and try to explain a concept. And here I use a table. Everybody understands how a table works. The first caveman didn't want to eat off the rocks anymore, and he invented a table, and it's got a top, a bottom, and four legs coming out of the corners. And Sean, let's just do a little experiment. I own the patent for the table. There's my claim. It's got a top, a bottom, and four legs coming out of the corners. Now you start making a table with three legs out of three corners and you leave one leg off. Are you infringing on my patent?
Yeah, I'm infringing.
So no, you're not infringing
No.
because I said mine has a top, a bottom, and four legs, and you made it with three legs. Well, I don't care if you make a table with three legs because it doesn't work. No one's going to buy a three-legged table, a table with a leg missing, right? When I write the patent as a patent attorney. So let's change the scenario a little bit. Let's say you make a table now with a top, a bottom, and four legs, but you put a hole in the middle for a wire for your computer. You put a Pez dispenser on one of the legs, and you put a pencil sharpener in the side of it. And you're the first person to do that. And you get a patent on that. But you go to make it. Now you put that whole thing together and you've made all those changes. Are you infringing on my patent now?
I think so, because I'm taking your basic idea and adding a few ancillary.
Exactly. You're exactly right. So you could add all you want to it. You could put a million legs on it. The bottom line is if you make a table with a top and bottom and four legs, it doesn't matter whatever else you do to it, that's going to be an infringement. And I'm going to stop you from doing it. So the claims are like a list of the parts. And when I go to try to get around that patent, when I try to make a product and sell it, I have to look at those claims, and this is what we do all the time. We right now we're working on a few of these where we have to put together what they call a claim chart, and the claim chart basically puts all the elements of what's there, and then on the chart there's a column of what the patent says, what elements are present in the product that's infringing, well, the alleged infringement. And then you have to go through. And if you can say yes, 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 all the way through that, all those parts are there. Does it have a top? Yes. Does it have a bottom? Does it have four corners? Does it have a leg coming off of each of those corners? If you have all yeses, then you're infringing. If you can say no to any of those questions, then you're not infringing. And if you have a bunch of no's, it's a stronger case. If you just have one no in there, and then it's a weaker case. And
If as an inventor, I discover that a competing product looks, very similar to mine, what, do I reach out to you? If you were the infringer, what do I do before I reach out or react?
Well, that's what happens. I have a lot of corporate clients as well as independent inventors, and they're constantly trying to say, "Oh, this product looks pretty good and it's making money. How could we make something to compete with it? And could if we made this product, would it infringe on their patent?" And that's another misnomer. People think, the company that's making the product, is that product itself covered by the patent? Sometimes, like we said, that product goes through changes over time and they're not even making what's on the patent.
Hmm.
So a patent doesn't give you a right to make it. It gives you a right to stop other people from making it. So in my example with the table with the Pez dispenser and the pencil sharpener and the hole in the middle, even though I get the patent for that because no one's ever made that, I still can't make it because I can't make the table in the middle of it all.
Hmm.
I can't make a table because I'm going to get sued. So what happens? I gotta get either a licensing agreement with the table guy that has the patent on the table, or I have to buy tables from him and put those and make all my adaptations to it and then sell it. So yeah, I mean, the one another thing that just popped in my mind too is what I just described before is called literal infringement.
Hmm.
So there's two types of infringements. There's infringement literally by doing exactly what they did, and then there's infringement by the doctrine of equivalence. So let's just say your patent had a piece of string as a part of it.
Mhm.
And then I changed the string to a wire. And I would argue it's different. I don't have a string. Well, the argument for the patent holder would be no, that's the equivalent. It does the
Mhm.
exact same thing. So what happens there is we go back into when we do our analysis, we would go back into the history. They call it the patent history, and because you can go online and see everything that happened in that history of the patent, of how they worked with the examiner to agree to a point where you got the patent. And if they had to change that string or that wire to a string or that piece to a string, then it's called patent history estoppel. You're stopped from saying that that's the equivalent because the only reason you got the patent is because you had to use that string. So it's
Hmm.
like one more level of analysis that we go through to see if there's an actual infringement. But the
Hmm.
truth of the matter in these type of things, when you own a patent, if it's close enough to argue, and before remember I said if you have a bunch of no's in that column,
Mhm.
it's a stronger argument than one no on one small little part. That if it's close enough, people are going to sue you. And at the end of the day, the sad reality of it is that the bigger threat is just fighting the lawsuit, not really worrying about how much you're going to lose or how much you're going to cost you to pay if you lose, but how much you're going to pay the lawyers over time.
Hmm.
These patent lawsuits are for multi millions of dollars. The attorneys get huge amounts, hundreds of thousands of dollars to fight these things out in court, and that's what you have to pay in order to see if there's even going to be um, if there's ever going to be a decision by the court. So what happens, most of the time on these things is that there's a settlement beforehand, and even though you don't have the strongest case in the world, the other side just wants to avoid the lawsuit and let's just get together and let's just settle this thing. So there's so much different strategies to that point, but the bottom line is if you don't have the patent, you can't say anything to anybody about anything as far as making that product because the only thing that's going to stop them is that patent.
Right. Well, and I think if if you have a patent, I think a lot of people assume that since you have an enforcement is going to be, automatic. But how does enforcement actually work? I mean, you alluded to some of the, the checklist and that sort of thing. I'm sure that comes into play. But, in the real world, how does enforcement work?
Well, everybody's familiar with the cease and desist letter.
Hmm.
Can we get a cease and desist? Now, you send out the letter, that's the start of the communication. And, sometimes clients send it by themselves by email and it just gets ignored, or you get the, go pound salt reply. And then I always say, well, if it comes from an attorney and it gets to and especially the bigger firms, it goes to the law department, at least they're going to take it seriously and do a review and see, is this a strong case or a weak case? And
Hmm.
then, and you have to have a poker face in these things, and you have to be able to say, look, if you don't cooperate here, we are going to sue you, and we're all going to end up in court. Let's try to avoid the lawyers and let's work this deal out. But yeah, without that patent, you there's no threat whatsoever. But yeah, it starts with that first communication, and of course, there's a notice requirement that you have to put them on notice, and you've seen on product it'll say patent pending or patent numbers on it. So
Sure.
that's certainly a deterrent. And a lot of times I ask clients, well, if you had seen this product out there with a label on it that said patented, would you even be here in my office trying to get a patent on this? Would you even think about it? And when we did our search, if we found this, would we try to avoid it? And so just the fact that you have a patent is a deterrent, and the fact that you've already spent the money on an attorney, and you're willing to spend the money on an attorney, and you're willing to sue it, that's all part of the poker game. I don't know if you play poker, but sometimes you push all your chips in when you have a crummy hand, and sometimes you push all your chips in and you think you have a great hand, and it turns out they have a better hand than you.
Yeah.
You just don't know. It's still a poker game.
Yeah, that's a great analogy. The let's say that, for sake of argument, that infringement is confirmed. How do you decide which path makes the most sense in pursuing your claim or enforcing your patent?
Well, there's so many different strategies, and it's who you're up against and how they're willing to communicate with you. But in that first letter, it's very important to do it in the right way. I have had clients and say, look, I want to be very aggressive, and I don't care if we go to trial. I'm scorched earth. We're fighting this all the way. Other ones is, really, I really don't want to get involved in this. I don't want to get sued myself. And when I say I don't want to get sued myself, is when you send a cease and desist letter and you make an accusation of infringement, you that party can say, look, there is an issue that needs to be decided by a court whether infringement occurs. And you, as the party that's accused of infringement, can pick and choose your venue and where you want to go and what court you want to bring it to.
Hmm.
And you can ask the court to have what's called a declaratory judgment.
Hmm.
So you could ask the court to declare that I'm not infringing. And you could have your own cross demands is to say, they sued me frivolously. I want um, attorney's fees, and you get yourself in this big fight. You got to be ready for the fight. So I could write a cease and desist letter that doesn't really tell them to cease and desist, but it says, look, we have this patent, and if you are infringing, you should just be aware of it. You should be aware of this patent. Or I
Hmm.
can say, we have this patent, and my client believes that you're infringing, and we've done our review and research, and we believe you're infringing, and we want you to pay us royalties and fees and stop to doing it, and we want you to talk to us. And but in those situations, you're risking that they file first. So you have to make that determination right from the beginning. Are we going to file it in our hometown court and not worry about them filing it in, I always say in some town halfway across the country, that we have to go and get a lawyer that, I'm not an attorney that's licensed in every state in the country. I don't think anybody is.
Hmm.
Some people have taken a lot of bars. I know when I was taking the bar exam so many years ago, the guy's name was Peeper, and he was taking a bar every year in a different thing, but he was teaching the bar course. So I imagine there's not too many people. So what happens is when we go into another state, I'm actually licensed in New York and Florida. I took two bars and the patent bar, which allows me to practice patent law anywhere. But you're not allowed. You'd have to be admitted into that federal bar. So what happens is you got to go and get somebody that's local to
Hmm.
handle it. Now you got two lawyers you're paying for, and you have to travel to different states. So there's a lot of strategy that gets involved.
Yeah, I mean, we talked about it earlier that, like, we just keep peeling back the layers, and there's new, a Future podcasts in all of this, I think, right? For sure. And you touched on this, and but I'm going to say it anyway. In some situations, I'm guessing infringement disputes could turn into licensing opportunities, right? Instead of litigation, as you do the homework. What's your experience there?
Exactly. Yeah, exactly. And sometimes they're interested and sometimes they're not. And and you work out deals and say, look, okay, we're selling three different types of products. We'll stop selling this one, and
Yeah,
we'll give you a license, we'll pay you a percentage of what we made on this particular one because like we talk about the new and improved models and things like that. But yeah, it's all on the table once you bring it out there. But nobody gets brought to the table without the patent. If you don't have the
right.
patent to start off with, you can't get there.
Yeah, that's interesting how a patent could be a springboard to some additional revenue. That's cool.
Yeah, and I don't mean to cut you off, but
All right.
IBM makes a huge amount of money for the innovation that they have that they don't use, that they
Hmm.
just license out. They don't even use, and that's
Right.
why every year they're the top in the world as far as filing and getting patents. They're always up at the top, and a big part of their portfolio is just patent revenue for things
Yeah.
that they don't actually sell.
Intellectual property. That's interesting. Well, how about this for the inventors out there who are listening? Maybe they're worried about copycats. How should they think strategically about protecting and monitoring their invention after the patent is granted?
So yeah, it's kind of like recognizance in
Hmm.
getting this information like in the military. We have to know what our opposition's doing. We have to keep it tracked on what the competition is selling and whether or not they're selling our product. And we have to be able to monitor and figure out who we going to send these cease and desist letters are out to. And that's a big part of it. And we when we file a patent application, we do a patent search just for patentability sake. And just to see, a lot of times you'll do an infringement analysis as well when we get something that's close, that are we going to even be infringing on this patent, so yeah, I don't think it's like get the patent, forget about it. You still have to be vigilant and guarding it and protecting it and sending out these cease and desist letters and starting lawsuits, and they talk about, you know, clients that have a reputation for suing people. And, right now I'm working on one where there's a lawsuit going on between two competitors.
Hmm.
And a third competitor calls me and says, these guys are suing them. Are they going to sue me next? Could you do an infringement analysis to make sure that I'm selling something that we have a good argument for, that we're not infringing, and we can show that we didn't intentionally infringe? We actually hired you to do an infringement analysis to prove that we want to be careful that we're not selling something that could be considered infringing. So yeah, I mean, it's always a constant thing, and sometimes it's like I said, I got hired because somebody sued somebody else.
Yeah, that's interesting. The sort of preemptive move, which tells me too a lot of, most people are honest brokers. They're not trying to infringe necessarily. So good stuff. Listen, as usual, as always, Vincent, thanks for this conversation. We're out of time, but I know
It always flies by so fast.
we'll have more opportunities to talk. Thanks everyone for listening to Guardians of Innovation with Vincent LoTempio. If you believe someone may be infringing on your patent, or you want to put a stronger protection strategy in place, Vincent and his team can help you evaluate your options and determine the best path forward. You can contact them at lotempiolaw.com to learn more. And if you found today's episode helpful, as always, don't forget to like, subscribe, and leave a review. I'm Sean O'Connor. Have a great day.
Thanks, Sean.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.